So guys, without any delay, without any wastage of time, let's begin the fifth lecture. Okay, before we have discussed with the fifth lecture, with the term confederation. In the last lecture, I have stopped with the term confederation, right? Confederation in the sense union of parties. Federation is the division of power, but confederation is the union of parties and they rule the government. See, if no party gets the majority, then they form a coalition government, right? That we call as the confederation. We have the Confederation of Indian Industries. It is nothing but group of Indian industries. Okay, by bringing up the group, we call it the confederation. Okay, fine. Okay, fine. I'll use my. Fine. So now in this lecture we are going to discuss about union executive and state executive. Okay, executive in the sense there are three things. Just remember, one is the president, the vice president. President is called the first citizen of India. Vice president is the second citizen of India, and the council of ministers along with attorney general of India. So this constitutes the what we call union executive. Executive at the union level. Okay? And what constitutes the executive at state level? Here it is. Kandriga, what do you call that in English? It irritates me, two times it has sting. Okay, fine. State executive consists of governor, council of ministers, advocate general. Okay, there is no vice governor here in the post. Okay, fine. We will discuss one by one what are the president, what are the powers of the president, what he can do, and how is he elected, what is his term. Okay. Article 52 to 78 speaks about the union executive, and Article 153 to 167 speaks about the state executive. Okay. Union executive. First is president. President article is from 52 to 62. Okay, from 52 to 62 it's president, but some articles are there like triple one. It is giving assent to bills. 123 ordinance making power of the president, and 143 is advisory. I mean, president can take advices from the Supreme Court. Okay, these are all the powers apart from this. So Article 52, which says that there shall be a president of India, and he is the first citizen of India. Okay, president is the head of the state, and who is the head of the government? He is prime minister. Okay, head of the state is president. In UK, it is hereditary, but in our constitution it is republic. Okay, the president is elected, but the governor is not elected. Okay, actually there was a provision for the election of the governor, but because of the conflict the governor was not elected. Like, see, already chief minister is elected, and if the governor is also elected, then there will be a clash between chief minister and governor, and it takes huge cost to conduct elections for the governor in direct manner. Direct elections for governor is a task with money, so it becomes very huge money to spend in order to elect the governor. And there are also many few puny reasons, like governor acts on his interest. Okay, so on his interest, giving him the whole adult franchise. So I mean, with the help of adult franchise, if you elect, then it is very difficult, and it goes the power goes to the hands of, already the governor is very powerful, and making him more powerful and giving autonomy is risky thing. So that's why we went for the governor is appointed by president. Okay, fine. Article 52 says that, see, both head of the state and head of the government is president in case of USA. In case of India, it is president is head of state, and prime minister is head of government. Okay. Fine. President is executive head of the union. He is the first citizen of the India and acts as a symbol of unity and integrity and sovereignty. He is the first symbol of unity, integrity and sovereignty of the nation. And so there is about the first article, which says that there shall be a president. 52 and 53 says that he acts according to the constitution, either directly or indirectly through officers subordinate to him. Okay, he acts in accordance with the constitution, and either directly or indirectly with the help of officers subordinate to him. So this is what this says. Okay. Yeah, first two articles are done, and these two are about the election of the governor. See, Article 54 says that there should be election for the president, and Article 55 mentions about the manner of the election of the president. See how the president is elected. Let me tell you in brief. Okay, who or he is elected with the help of single transferable vote through secret ballot, and who are all the parties involved who can vote in the president's election is his election is indirect election. Okay, so indirectly whatever we people elect, those people elect the president. So the first thing, first category of the people who can elect is elected members of Lok Sabha, elected members of Rajya Sabha. See, nominated members are eliminated. Okay, and third thing is elected members of state legislative assemblies. Fourth, elected members of legislative councils. If there is a legislative councils, then elected members of the state legislative councils are also part of the election of the president. Sorry, legislative councils are not part. Okay, state legislative assemblies of state, and elected members of state legislative assemblies of Union Territory of Delhi and Pondicherry. So these four members who are elected, not nominated, okay, take part in the elections. See, value of these first two categories belongs to parliament, and they are called member of parliament. Okay, and these two categories are called member of legislative assembly. Okay, so how the value of each vote is determined? It is determined in such a way that, see, total value of votes of all MLAs is equal to total value of votes of all MPs. So this is the theme of how the voting is done. Okay, let me explain you in brief. See, there are some MLAs. Okay, X number of MLAs, and the population of the state is Z. So the total population of the state divided by total number of MLAs into 1 by 1000 is the value of that particular MLA's vote. See, in Andhra Pradesh, the value of the vote of MLA for the president differs from the Telangana MLA. Okay, because it depends on the population here. So population divided by total number of MLAs into 1 by 1000 is what we get value of vote of one MLA. Okay, and what is the value of MP equal to total value of all MLAs divided by number of MPs. So total value of all the MLAs. See, value of vote of one MLA is population divided by total MLAs in that particular state. So in the state of India, there will be in the state of Andhra Pradesh there will be few MLAs. In the state of Madhya Pradesh there will be few MLAs whose value of vote. So if we combine all the values and divide it by total number of MPs, then we will get the value of vote of one MP. Okay. So if we transfer this here, number of MPs into value of vote of one MP, these two becomes total value of total number of MPs. So total value of all the MPs is equal to total value of all the MLAs. This is what I have written here, right? These two things, number of MPs into value of each MP is equal to total value of all the MLAs vote. The vote of all the MLAs. So in this way, this particular thing works. And if you want to become the president of India, the first thing what you want to do is, I'm discussing about Article 54 and 55. Okay. and you need to do two things. One is 15,000 cash deposit. You need to deposit this in RBI, okay? And second thing, you need 50 electors as proposers and 50 electors as seconders. See, this thing was done in 1997, okay? 1997, this particular rule was what, that you have to deposit 15,000 in the RBI and you need to have 50 electors as proposers and 50 electors as seconders. Before 1997 it was 2,500 and this thing was 10, okay? Only 10 proposers were there and 10 seconders were there, 10 electors were there as seconders. But in order to eliminate the serious non-serious candidates, this particular provision was brought out in 1997, okay? So this is the manner of the election. So you have understood, right? If you did not understand, just come to me, I will explain in brief, okay? Simple thing, guys. Total value of votes of all the MLAs in the sense, value of each MLA's vote is different, okay? In Andhra Pradesh, total population divided by number of MLAs is the value of vote of one MLA. Like that, total value of votes of MLAs of Andhra Pradesh is total number of MLAs into value of vote of one MLA, okay? So Andhra Pradesh, we have got it, right? In the same way, we'll do it to Karnataka, Kerala, Tamil Nadu and all the other states. And if we combine all the values and divide it by the number of MPs, then we will get the value of vote of one MP. In the sense, total votes of all the MLAs is equal to total value of votes of all the MPs. And remember this thing, it will be a tricky question. Elected members of legislative, Lok Sabha, elected members of Rajya Sabha. Lok Sabha is also called as lower house and House of People, and Rajya Sabha is also called as upper house and it is called as representatives of state, okay? So only elected members are there in the parliament. In case of impeachment is Article 61, okay? Article 61 is the impeachment. Let us discuss here only, okay? So impeachment, only members of parliament. See, nominated members are also eligible for impeachment of the president. So if a president violates the constitution, then he is eligible for impeachment. Prior that 14 days notice should be given to the president that he is going to be impeached, and 2/3 of the majority. Last category of majority, I have explained the types of majority. So impeachment of the president comes under 4th category of the president. So this particular thing can be initiated in both Lok Sabha or Rajya Sabha. Either one house they can initiate and they need to pass with the help of 2/3 of the majority. Then the president starts impeached. Thankfully, no president has been impeached till now, okay? Because 2/3 of the majority, in the sense, whatever the president, 2/3 of the total majority should vote against this, okay? Then only the president gets impeached. So we have discussed about these elections and we have discussed about the Article 61, okay? So hope you are all understanding very well whatever I am saying, okay? This is very important, okay? Elected members of legislative, Lok Sabha, Rajya Sabha and state legislative assemblies of all the states and state legislative assemblies of Union Territory of Delhi and Pondicherry. Now Jammu Kashmir is also included, okay? See, this much Ramayana is there for the. I don't. Fine. This much Ramayana is there for election of the president, right? But in the case of governor, no. On the pleasure of the president, whoever can be the governor, there should be a governor of the state. Article 153 states. And all the executive power of the state shall lie in the governor. Article 154 states it. If you want to appoint a governor, the same governor can be appointed for more than one state also. So there was many commissions, okay? Sarkaria Commission, Punshi Commission, which recommended the independence of the governor. Whenever the governor wants, he can make the president's rule. Article 356 was the president's rule. In emergency provisions, I have told that also, okay? So it is a misuse of his powers, but still the constitution is going on. Fine. Okay, we have discussed about the election. Article 56, term of the office. Okay, a president shall hold the office for the period of 5 years. Okay, for the period of 5 years. '56, right? So, in case there is a vacancy and if he wants to go, he can give the resignation letter to the vice president. Okay, if vice president wants to vice president. Okay, where this article 63 says that there shall be a vice president of India and he is second citizen of India. And if president wants to resign in between this 5 years term, then he can write the resignation letter to vice president and just move off. And or he can be impeached also. In this way, he can be removed, but the term is 5 years, or the successor takes over. Whatever is early, then it goes like this. So Article 56 and 57 speaks that re-election. Okay. So for India, so he can be re-elected many number of times. This I'm little bit confused whether a president can be re-elected for any number of times or not. But in USA, the president can be elected only for 2 times. Okay. After 2 times, if you want to contest elections, no, he is not eligible because he already has been the president of USA for 2 particular terms. And for India, it is any number of times. I mean, re-election can be conducted any number of times, and the same president can come to power any number of times. This is what the constitution says. Let me look at it. Okay. 57 eligibility for re-election, it is there. See, my laptop, it is getting updated. Okay. So my laptop got stuck and it was getting updated. That's why I kept my laptop aside, and 50% of my preparation depends on it. I need to reduce the dependency on it. So that now I'm teaching you from this particular thing, and it is only given that elections can be Article 57 speaks about the re-election. That's what eligibility for re-election he has given. Okay. And Article 58 is the qualification of the president. See, if you want to become the president of India, you have to have these qualifications. The first is you have to be citizen of India. Second is you need to have completed 35 years of age. And third thing which you need to do, you should not hold office of any profit of office of profit. Okay? See, if you office of the profit in the sense, if you hold any government position or the business, which with the help of you can influence with the help of the president's power. Okay, you are the president and you are holding any business. Then if you say, then all the customers will come to your office only because you are the president. So this should not happen. Okay, if you are the panchayat secretary or you are collector of particular thing, then you are also president, then there will be special treatment. That is called office of profit, either government or business, which hinders that particular thing, which you can use the influence of the president on the others. Okay, and you can take the profit. That particular thing is office of the profit because it interests. Okay, interest should be there. Okay, interest should be there in the sense interest matters, guys. Like interest of, so your interest is there in business and you are president also, then you will not be able to take the decisions unfairly, unbiasedly, independently, because already you have the thing with your office of the profit and it keeps attracting you. To become the president of India, you should not have any office of profit there. Remember it. Okay? So these 3 things are the Article 50. Article 58 of the Constitution. Okay? And 59 says member of either house of the parliament. See, if you are the member of either house of the parliament and if you become the president, then you need to vacate the particular house. and you should be able to qualify for the elections of either Lok Sabha or Rajya Sabha. Okay, then only you can become the president. And once you become the president, you need to abandon that. Fine. And Article 60, oath and affirmation. Only president and governor. Okay, these two guys take the oath. Okay, they take the oath like this. Here I have written somewhere. See, preserve, protect, and defend the Constitution. So they take the oath, okay, oath and affirmation. Only president and governor. They too take the oath to preserve, protect, and defend the Constitution. So who takes the oath to preserve, protect, and defend the Constitution is the governor of the state or president of India. And all the other guys like chief minister takes oath differently. Not this, okay? Preserve, protect, and defend the Constitution. And who administers the oath to the president and the governor? To president it is Chief Justice of India, and to the governor it is Chief Justice of High Court of that particular state. Okay, fine. We have discussed up to Article 50. Article 61 also I have discussed how the president is getting impeached. 2/3 of the majority should be proved. Okay, and there should be 14 days prior notice to the president before passing this motion, and this motion can be started in either Rajya Sabha or Lok Sabha. Fine. Article 62 is the vacancy of 6 months. Now, accidentally the president has died, and within 6 months the new president should be elected. Or if the president term is going to expire, then before the expiry of that particular term only, the president's election should be conducted. Now Draupadi Murmu is the new president after Pranab Mukherjee. So before the expiration of Pranab Mukherjee's term, this Draupadi Murmu's elections were completed, and the day the Pranab Mukherjee got his term completed, the next day only our Draupadi Murmu joined that particular thing. So in this way, the manner of the election should be conducted. And if by chance, like Abdul Kalam sir died in the middle, right? Within 6 months, the elections should be conducted, and the time gap should be maximum of 6 months. Okay. Until then, Vice President acts as the president. Now I have discussed almost everything about the president. Now we will go for the Vice President. Vice President is also the second citizen of India. Okay. See, there are many powers and functions of the president, which is given in this particular book, and I will read out in brief and in fast in order to make you explain what is what. Okay. See, there are different kinds of powers, like 6 kind of powers are given here. Can you see this? Yeah, executive powers, legislative powers, financial powers, judiciary powers, diplomatic powers, military powers, emergency powers. Executive powers in the sense, all the actions are taken in the name of the president, and he appoints major executive posts like Chief Justice of India, Chief Justice of High Court, judges of High Court. He makes rule for more convenient transactional business of the country. He appoints Attorney General of India and determines his remuneration. He appoints Comptroller. CAG also is Attorney General. CAG also is appointed by President, and he can appoint interstate council to promote interstate relations. He directly administers the union territories through administrators appointed to him, and he can declare an area should be scheduled area or not. Okay, these are all the executive powers through which he executes the particular law. What are the legislative powers? Ordinance making power of the president, which is the article. It is Article 1, 2, 3, and 2 and 3 is the article making ordinance making power of the governor. Okay. So he can summon, prorogue the parliament and dissolve the Lok Sabha. See, summoning and proroguing of the session is done by president, while the adjournment is done by the speaker or presiding officer of the house. Okay, someone in the sense starting the session. Okay, prorogue in the sense ending the session. Okay, he can summon. Okay, he can address the parliament at the commencement of the first session after each general elections, and and the first session of each year. Every year there will be first session, it will be addressed by the president. After general elections, the first session will be addressed by the president. This is what they said. He can send messages to the houses of the parliament whether with respect to bill pending in the parliament or not. He nominates 12 members to Rajya Sabha from. See, we will discuss in the legislature. Okay, what is Lok Sabha, what is Rajya Sabha, and what are all the nominated members. But remember, the president nominates 12 members to Rajya Sabha who are experts in these fields, like literature, science, art, social service. These 4 things they are expert. Then he nominates. He nominates 2 members to Lok Sabha from Anglo-Indian community. This was already withdrawn, okay, through which constitutional amendment. Just comment in comment box. He decides on question as to disqualification of the members of the parliament in consultation with the Election Commission of India, okay. When a bill is passed by the state legislature, is reserved by the governor for the consideration of the president. The president can give his assent to the bill, can withhold his assent, or direct the governor to return the bill for the reconsideration of the state legislature. Should be noted that there is no obligatory for the president to give his assent, even if the bill, okay, fine. So when a bill is passed in Lok Sabha or Rajya Sabha or in the parliament, like that, and it is waiting for assent, then he should give his assent in order for a bill to become act, okay. So he can give his assent, he can withhold his assent, or he can send back to the parliament for reconsideration, okay. Once reconsidered and passed again with the same, with or without amendments, then the president can must give the assent. It is obligatory for the president after reconsideration to give the assent. But in the case of state legislature, the governor may send back the bill. I mean, it is in the case of governor, right? For the state legislature, the same thing. He can give the assent, he can withhold the assent, or he can send it for reconsideration. And the fourth thing for the governor is he can reserve the bill for the reservation of the president. Now, president can give assent, or he can withhold the bill, or he can direct the governor to reconsider the bill, and once reconsidered, it is not obligatory for the president to give his assent. You understand the difference? I'm telling you with all my skills in order to make you understand, okay? So these are all the legislative powers. We have discussed about executive, legislative powers, financial powers. What are the financial powers? Money bills can be introduced in the parliament only at his recommendation. So money bills can be introduced in the parliament with his recommendation only, and he should give the assent for money bills, I think, because it is with the help of with the present recommendation only it was introduced. Money bills will be only introduced in Lok Sabha, and it is passed by simple majority. Okay, he causes to be laid before the parliament the annual financial statement, budget. Okay, he lays the budget before the parliament. Demand for grant can not be considered. I mean, no demand for the grant can be made except on his recommendation. He can make advances out of the contingency fund of India to meet any unforeseen expenditure, and he constitutes finance commission after every 5 years to recommend the distribution of revenues between the central and states. Finance commission, in order to distribute the revenue collection between central and the states, this particular thing, after every 5 years he constitutes the finance commission. Okay, what are the judicial powers of the president? See, a president can do 4 things. I told you about the ordinance making power of the president, right? I am telling you about the judicial powers. So in judicial powers, he can appoint, I will tell you about this pardoning power, what is pardon, commutation, remission, respite and reprieve in shortly. Before that, there are a few formal things which presidents do as in order to fulfill his judicial powers, okay? So he appoints the Chief Justice and other judges of the Supreme Court and High Court. He can seek advice from the legislature or from the Supreme Court on any question of the law of the fact. However, the advice tendered by the Supreme Court is not binding. He can grant pardon, reprieve, respite and remission for the punishment, or suspend or commute. So this is what I am telling. Okay? Article 143 says that he can take the advice of the Supreme Court on any matters. of the interpretation of the law, and the advice is not binding on the president, and he can give these pardoning powers of the president in the sense, pardon in the sense annuls the convict or annuls the accused of both uh, imprisonment and sentence and conviction, both is annuls, pardon in the sense it cancels all the punishment and you are set free if the president gives a pardon. Commutation in the sense substitute with higher punishment with the lower punishment. Remission in the sense reduces the amount of the sentence. Example, it was 7 years, then it will make it 2 years, like that. Remission. Commutation, it will substitute the higher amount of punishment with lower amount of punishment. Remission in the sense it will reduce the time period of that particular thing, but the sentence remains that only. It does not rigorous imprisonment with rigorous imprisonment for the 2 years instead of 7 years. In the case of commutation, rigorous imprisonment for 7 years is exchanged with normal imprisonment, not rigorous imprisonment, normal imprisonment for 7 years. The time period is not altered in the case of commutation, but here only time period is altered. Remission. Respite in the sense there are special consideration, like if you become pregnant or if you are old and you are not able to withstand the pressure inside the prison, then you can the sentence can be relaxed. And what is reprieve? Stay the proceedings, stop till the direction of the petition is submitted. So reprieve in the sense stop, hold on, pause, like that. It directs to the courts. So these are all the pardoning powers of the president: pardon, commutation, remission, pardon, commutation, remission, respite, and last thing is respite. See, governor is also having these pardoning powers, like pardoning or commutation, remission, respite, and reprieve. Respite, reprieve, but he cannot pardon the sentence by court martial, and he cannot pardon death sentence also. If a convict if accused is sentenced with death sentence, then only president should pardon him. The governor cannot pardon the death sentence. So these are all the judicial powers of the president. And diplomatic powers in the sense, the international treaties and agreements are negotiated and concluded on behalf of the president. However, they are subjected to approval of the parliament. He represents India in the international forums and affairs and sends and receives diplomatic ambassadors. Military powers in the sense, he is the supreme commander of the defense forces of India. So who is the supreme commander of defense forces of India? It is president. In that capacity, he appoints chiefs of army, the navy, air force. He can declare war or conclude peace subject to approval of the parliament. Emergency provisions I have discussed. Article 352 is national emergency, 356 is president's rule or state emergency, and Article 360 is financial emergency. These are all promulgated with the help of president only. Veto powers: absolute veto is there, suspensive veto, pocket veto, president veto over state legislation. See, I have told you about the pardoning powers of the president, right? Article 72 says about the pardoning powers of the president. I have told you, right, about pardon, respite, remission, commutation. 4 things: pardon, commutation, respite, remission, reprieve. 5 things. Reprieve in the sense stay on the proceedings. Respite because of special conditions. Pardoning the whole sentence. Commutation, reducing the sentence, and respite, reprieve, remission is substituting 7 years punishment, reducing the period of the punishment is what is called repression. See, ordinance making power also have discussed. What else is remaining? This veto is removed. Okay? A bill passed by the parliament can become an act only if it receives the assent of the president. When such bill is presented to the president for his assent, he may give his assent, he may withhold the bill, he may return the bill for reconsideration. Okay. So the veto power enjoyed by the executive in the modern state can be classified into the following four types: absolute veto, qualified veto, suspensive veto, and pocket veto. Absolute veto is not there in the case of India. Okay. Nowhere it is used in the India. See, absolute veto in the sense it refers to the power of the president to withhold the assent to the bill passed by the parliament. The bill then ends and does not become any act. Usually, this veto is exercised in the following two cases. Okay, with respect to private members' bills, with respect to government bills. But before the assent. With respect to government bills, when the cabinet resigns, then he can. Okay. So if the cabinet resigns, a bill is passed and is waiting for the president's assent, and the cabinet resigns. A new cabinet is formed, and if new cabinet advises the prime president not to give his assent, then he should not give his assent. Then absolute veto, with the help of absolute veto, the assent is not given and the bill ends then and there. Okay, in 1954, President Dr. Rajendra Prasad held his assent to the PEPSU appropriation bill. The bill was passed by the parliament and the president's rule was in operation in the PEPSU. But the bill was presented to the president for the assent. The president's rule was revoked. Again in 1991, President Governer-CoM is suspended to the salary allowances pension. So this is how they can stop the bill from becoming the act. Suspensive veto, the bill when he returns a bill for reconsideration of the parliament. However, the bill is passed again by the parliament without the amendments again to president. Suspensive veto in the sense he is suspending, he is taking his time to set it away. He is suspending the bill to become an act for small period of time by sending back the bill to the parliament for reconsideration. However, after reconsideration, the president is bound to give his particular assent. Okay, but this is a suspensive kind of veto. Pocket veto. So in the case of constitutional amendment bills, he must give his assent. Okay. 24th Constitutional Amendment Act made it obligatory for the President to give his assent to the constitutional amendment bills. There is no reconsideration. Okay. Pocket veto in the sense he will just take the bill and keep it in pocket and it remains in the pocket forever. In this case, the President neither ratifies nor rejects nor returns the bill but simply keeps the bill pending for an indefinite period. This power of the President not to take any action on the bill is known as pocket veto. Okay. The President can exercise the veto as Constitution does not prescribe any time limit within which he has to decide decision with respect to the bills presented to him for his assent. So there is no time limit within which period he should give the assent. In USA, on the other hand, the President has to return the bill for reconsideration within 10 days. In USA, if you get a bill for your signature or for your assent, then within 10 days he can send it back to the reconsideration or he has to give his assent. Okay. Hence, it is remarked that the pockets of Indian President is bigger than that of the American President. So American President's pockets are very small because of the 10-day limit. Okay. But Indian President's President's pocket is very large because there is no time limit and he can exercise the suspensive veto on the bills. So this is the example. Okay, 1986, President Zail Singh exercised the pocket veto with respect to Indian Post Office bill. The bill passed by the Rajiv Gandhi government imposed restrictions on the freedom of press and hence was widely criticized. After 3 years, in 1989, the next President Venkataraman sent the bill back for reconsideration, but the new National Front government decided to drop the bill. See, in this way, the justice is restored and the fundamental rights of freedom is also ensured with the help of pocket veto. Okay. See, there is no pocket veto for constitutional amendment bills. He may ask this in the prelims exam. There is no pocket veto for constitutional amendment bills. There is no pocket veto for money bills also. Let me check. Okay. Article 108 says the joint sitting of the House. There is no joint sitting for both money bill and constitutional amendment bill, and there is no uh, pocket veto for constitutional amendment bills. This is the 24th amendment. For money bills, he can use the pocket veto. Recently, we have seen the example also. Okay. Over state legislation, see, the governor may reserve the bill for consideration of the president, right? Then what can the president do? He may give his assent, he may withhold his assent, he may direct the governor to return the bill. President is not bound to give his assent to the bill. If it is reconsidered and sent back, this means that the state legislature cannot override the veto of the president. So this is all about the veto power of the president. Okay, suspensive veto, pocket veto, and absolute veto. Absolute veto is not used in anywhere in the constitution. I guess I have not written about the veto powers of the president. Yeah, I have written. Qualified veto is not. India, there is no qualified veto. Okay, there is absolute veto. Withholds the assent to the bill. Indian president does not have except private members' bills. So for absolute veto can be used in the case of private members' bills only. With respect to government bills, when the cabinet resigns, then only he can use. With respect to private members' bills, private members in the sense who are not ministers in the parliament, public members in the sense who are ministers and are the part of council of ministers. Okay, fine. Qualified veto, president is not giving assent. Parliament can pass with a higher majority. Bill can become the act. Okay. Qualified veto is not there for the Indian constitution. Okay, fine. Ordinance making power of the president I have discussed with you very briefly. What else is remaining? See, Article 73 says that the extent of the executive power of the union. For the states, whatever the legislative jurisdiction is there for the state of Andhra Pradesh, the Parliament of Andhra Pradesh, in a sense, Legislative Assembly of the Andhra Pradesh, to which extent he can make laws, till that extent the power of the Governor of Andhra Pradesh spreads. And for India, till the extent where the Supreme Court has the jurisdiction. Supreme Court has the jurisdiction over all the territory of India, right? Union of India. So in the same is the jurisdiction of the Union of India. That's what Article 73 says. Okay. Okay, fine. We'll go to Vice President. Vice President is also called ex officio chairman of Rajya Sabha. Here also there is an electoral college, okay, which elects. I have told you in the case of what are all constitutes the electoral college for the president, right? In the case of vice president also there is an electoral college which consists of members of both the houses of the parliament. Okay, members of both the houses of the parliament. Impeachment. Impeachment is quasi-judicial and understood. So the nominated members can participate in the impeachment of the president, and they do not participate in his election. The elected members of the legislative assemblies of the state and union territories of the Union Constitution do not participate in the impeachment of the president, though they participate in the election. No president has to. Okay, fine. Impeachment I have told you, right? In case of vice president, see, in case of the election disputes, of the president, then the final authority is with the Supreme Court. Okay. So Vice President, Article 63 says there shall be Vice President of India, and Article 64 says he is the ex officio chairman of Rajya Sabha. Okay. He is the ex officio chairman of Rajya Sabha. 56, 55, 50, everything we have discussed, right? 62 also we have discussed. This we have discussed. Article 72 also we have discussed. All the doubts regarding the election of president as well as vice president shall be by Supreme Court of India. 71 also we have discussed. Extent of the executive powers, this also we have discussed. Article 63, 64, it is the ex officio chairman of Rajya Sabha. See, Article 65 says that Vice President shall become the President in case there is a vacancy for the President. This is not in the case of USA. Again, only for 6 months. After 6 months, new President is elected. In the case of USA, the Vice President continues as President for the remainder time of the period, and the next elections are conducted. Okay. Elections of Vice President, Article 66 says term of the Vice President is 5 years. Elections. What consists of the electoral college? It is Parliament. Okay, 2 houses of the Parliament elected or nominated. So term of office is 5 years. I have discussed it. Similar manner. Okay, through single transfer vote only Vice President is elected. Similar to the President. Okay. In case of Vice President, 20 proposers and 20 seconders should be there. In case of President, it is 50 proposers and 50 seconders, right? In case of Vice President, it should be 20 promoters and 20 seconders. Then you can participate. Okay. So what 63 says? So what are all the qualifications of the Vice President? He should be citizen of India. He should have completed 35 years of age. He should be qualified for the election as the member of Rajya Sabha of Council. He should not hold any office of the profit. So in case of President, the impeachment in the sense, Article 67 says about the impeachment, right? Vacancy and impeachment. Okay, impeachment. If you want to impeach the Vice President, you have to pass it in Rajya Sabha only. In case of President, it can be started in both. The resolution can be started in both Rajya Sabha and Lok Sabha. In case of this Vice President, it should be started in Rajya Sabha only. Okay. And simple majority must agree. If not, so Lok Sabha should also agree to what Rajya Sabha says. If not, he is not removed as the Vice President. Okay. My laptop is getting updated with the help of Windows 10. That's why it is becoming late. Okay. Fine. Vice President, oath and affirmation. He takes oath as to be true faith and to bear true faith and allegiance to the Constitution of India. In case of President, it is to defend, protect, and preserve, protect, and defend the Constitution. In case of Vice President, he has to bear true faith and allegiance to the Constitution of India. Discharge of the functions of the Vice President is done in Article 70 of the Constitution. Okay. So, Constitution as itself does not allocate any functions to the Vice President. He acts as the ex officio chairman of Council of States. Vice President is a member of Council of States. Okay. So, Council of the States in the sense it is Council of the States in the sense it is Rajya Sabha. Deputy chairman of Rajya Sabha is also there. In case of the vacancy of the President, Vice President shall act as President for the period of 6 months. This also I have told you. In case of President and Vice President are vacant, Chief Justice of India. If Chief Justice of India is also vacant, then most judge of Supreme Court will take it as the president will come to the position of the president and discharge his duties. So Article 71, all the doubts and elections of Vice President and President is over. Okay, fine, we have discussed about the President, Vice President, now Council of Ministers. Article 70 or Article 91 says that the strength of the Council of Ministers should not exceed the 15% of the total strength of that particular assembly. In the case of Parliament, Council of Ministers strength should not exceed 15% of 543, which is the strength of Lok Sabha. In the case of state legislative assemblies, 15% of their respective strengths. Okay. Article 74 says that there should be Council of Ministers to aid and advise the President. Whether this aid and advice is binding on the President or not is decided in Article 74(1). So, Council of Ministers should be there to aid and advise the President, and President shall act in accordance with the advice. This was done during the Indira Gandhi period, and this was 42nd Constitutional Amendment. Again, the 44th Constitutional Amendment said that the President can send back the advice for the reconsideration, and once the Parliament passes with the reconsideration with or without any amendments, then it is mandatory for the President to act in accordance with that particular advice. So this particular advice and the acts of the President should not be inquired in any court. Okay, 74, 1, 2, 3. This is all this is. And 75 is Prime Minister is appointed by President and other ministers by Prime Minister on the advice of. So, Prime Minister is appointed by President, and all the other ministers are appointed by President on the advice of the Prime Minister. This is what Article 75 says. And Article 75 1 year says that 15% of the strength of the Council of Ministers. See, let me explain you in brief. There is Lok Sabha. Okay, in that smaller portion, which is 15% of the strength, is the Council of Ministers. In Council of Ministers, smaller strength, it is Cabinet of Ministers. It is like this. Okay, 1, 2, 3. This is Lok Sabha. This is Council of Ministers. This is Cabinet Ministers. See, Cabinet Ministers are the core of the body, okay? They just implement the laws. So, Council of Ministers are around 60 to this Council of Ministers, 60 to 70 Council of Ministers are there. Your Cabinet Ministers will be 20 to 25. Maximum Cabinet Ministers will be. So, the duty of the Cabinet Ministers is to enforce the collective responsibility of Council of Ministers. And the collective responsibility, this 60 members or 60 to 70 members are collectively responsible to the Lok Sabha. And this 20 to 25 members Cabinet Ministers formulate the process and supervise the implementation by Council of Ministers. Whatever the process is there, how to execute that particular thing, then these 20 to 25 people will formulate, and Council of Ministers will execute the formulated plan by Cabinet Ministers, and Council of Ministers are responsible to Lok Sabha. Okay, this is Lok Sabha. This you have understood, right? In Council of Ministers there are 3 types of ministers. Okay, like Cabinet Ministers, Minister of State, and Deputy Ministers. This Council of Ministers consists of 3 types of ministers: Cabinet Ministers, Ministry of State. Minister of State is below the minister, okay, below the Cabinet Minister, immediately is subordinate to him. And Deputy Ministers are also there. Article 75(3) says that Council of Ministers are collectively responsible to House of People, that is Lok Sabha. What is the Council of States called? It is called Rajya Sabha, or Upper House. Lower House or House of People or Lok Sabha. Everything are common, but in exam try to use House of People. And for Rajya Sabha exam, try to use Council of States. It will be good. It will give a good impression in the answer writing. Okay, don't use Lok Sabha, Rajya Sabha. Okay, all the Lok Sabha, Rajya Sabha, it is for debate by the politicians. For officials, it is a House of People or Counts. Okay, fine. So ministers hold office for pleasure of the president. There are few articles in Article 75 which are not that important. Okay. Yeah, not these are all important articles. 74, 1, 2, 3, 75, 1, 2, 3, 1, 8. Okay, these are all important articles. Just remember that. So that's it about Prime Minister. Prime Minister is the head of the government. He recommends the members to be. He recommends to the president who should be the ministers or the other ministers. With the extent of PM, entire council of the minister falls. So if Prime Minister exit all the council of minister falls, and there should be a new elections. Okay. In relation to President, Council of Ministers recommend proposal for legislation, give information to the President. In respect to President, okay, Prime Minister should give the information to the President. Prime Minister will ask to reconsider. President will ask. See, Prime Minister can be from either Rajya Sabha or Lok Sabha, no problem, okay. Announces the policies, convenes the cabinet meetings. Cabinet Secretary, Chairman of the Civil Services Board is appointed by Prime Minister only. So the last article is about Article 76, which tells about the Attorney General of India. Okay, Attorney General of India is the advisor to the executive. Whatever the cases are there in the Supreme Court, right? So in Supreme Court, from the government side, there should be a lawyer, and this particular person is called the Attorney General of India. Okay, he is the highest law officer of the country. He is appointed by the president, and he should be removed as same as the Supreme Court judge by passing the majority in Parliament. Okay, and he should be citizen of India. He should be judge of High Court for at least 5 years, or advocate of High Court for any 10 years, or eminent jurist in the opinion of the president. Then that particular person can be appointed as the Attorney General of India. See, the term of office is not fixed. Okay, on the pleasure of the president, he can be the Attorney General of India for n number of period or so. Okay, he can also be removed at any time. Okay, legal advice to the government of India is given by Attorney General of India. So this is all about the Attorney General of India. Attorney General cannot vote in the Parliament, but in every session he can go and participate in the session. Look what the proceedings are going on. Okay, what are all the privileges of MP? The same thing is given to the Attorney General of India. This is all about the union executive. Okay, so once you are familiar with the union executive, this particular thing, state executive, becomes very easy for anyone to understand. Okay, Article 53 states that there should be a governor of the state, and he shall be appointed on the pleasure of the president, and more than one governor can be appointed for all. More than one states, there one governor can be appointed. One governor can be appointed for more than one states. This is what I meant. Okay, Article 154 says that executive power of the state shall lie in the governor. Article 53 states here. Article 53 states that executive power of the union shall rest with the president. Okay, here the governor state. Okay, appointed by the president. Term is 5 years on the pleasure of the president. Okay, 5 years. It is generally fixed, but on the pleasure of the president, he can be transferred or removed or reappointed or whatever. Maybe. Article 57 says about the qualification. You to be citizen of India should have completed 35 years of age. Okay, Article 158 says governor not member of the legislature. So Article 158 says that if you are the MLA, then you need to, once you become the governor, then you need to vacate your seat. You should not be a member of legislative assembly. Okay, Governor should not be member of legislative assembly. And 159 says about the oath and affirmation by the governor. The oath and affirmation is administered by the Chief Justice of High Court, and he takes oath as to preserve, protect, and defend the Constitution. Is it visible clearly? I think it is visible clearly now. Okay. Almost I have completed the lecture. Nobody is reviewed. Okay. Article 159: preserve, protect, and defend the Constitution. Okay. Fine. Article 160 says about the discharge functions of the president. What is Article 160? See, Article 111 says about the assent to the bills, right? Here, Article 200, okay? 200, assent to the bills by the governor of the state legislative assemblies, okay? Assent to the bills. Article 111 says about the assent to the bills, right? Here, Article 200 says about the assent to the bills, okay? Fine. 123 is the ordinance making power of the president, right? So 213 is the ordinance making power of the governor. And what else? 143 is advisory jurisdiction of Supreme Court. And what is advisory jurisdiction of? There is no such thing. Okay, fine. So what is the time period of ordinance? It is 6 months, 6 weeks. Okay, 6 months. Within 6 months, it should be approved by the parliament. Once the ordinance is passed, ordinance making power in the sense, the president or the governor passes laws. Whatever the parliament, whatever there is a power for the parliament to make the laws on the same topics, this particular thing, president or governor can pass the laws when both the houses are not in session, or either one of the houses is not in session. Then in order to meet the urgent requirement, he can pass the ordinance and he can make a law, and that law must be passed within 6 months. Okay, so maximum gap between two sessions is 6 months, and to reassemble the assembly is 6 weeks. So maximum it is 6 months, 6 weeks within which the ordinance should be approved. And after every 6 months, this ordinance can be renewed by the parliament by passing with the help of simple majority, I guess, or special majority. Just check it out, okay? So I have told you about article discharge of functions of the article 160. I am not getting what this, but I will explain in the next class. Like I have started the confederation, right? Article 160. I will start in the next class. Okay, 160. Remember this. Next class is about legislative and legislature, right? I will start it. Fine. Article 163. There should be council of ministers to aid and advise of the governor. So Article 74 says that council of ministers to aid and advise the president. Here Article 163 says about the council of ministers aid and advice for the governor, and this particular advice is not compulsory. If it is reconsidered, it is compulsory in case of union, but it is not compulsory in the case of state. Article 161, pardoning powers of the president. Similar to the president, the governor also pardons the power, but governor cannot pardon death sentence. There's the difference, okay? So Article 161, pardoning powers of the president. What are the pardoning powers? One is pardon, respite, remission, reprieve, commutation. These 5 things are the pardoning powers of the governor and president. So extent of the executive powers of the governor, 162 is the article, okay? 163. So to which extent? To that which the legislature can make laws, to that extent the power of the executive extends, okay? In case of union also, which is the article, extent of the executive powers of the union, it is 73, okay? Before 74, 73 is the extent, 72 is the pardoning powers of the president. Here pardoning powers of the governor is 161, okay? 162 is the extent of the. So 163 I have told you, and 164 other provisions like chief minister and governor. So article 1A, 15% of the strength of this 91st constitutional amendment, right? So which is the article in which it says that it should not exceed the 15% of the strength of the House of Ministers. Here it is, okay. Article 75 1A. Here it will be Article 164. So Article 165 says about the Advocate General. He is the law officer of the state government, similar to the Attorney General of India. There is Advocate General of India. And 77 and 78 speaks about the conduct of the business of Government of India by President and the duty of Prime Minister to furnish the information to the President. Similarly, 166 says about the conduct of the business of the government of that particular state by the Governor, and 161 says that it is the responsibility of Chief Minister to furnish the information to the Prime Minister. So this is all about the state executive. I told you in one class covering all this is very, very much difficult, and it is a lot of time that I have covered it. And thanks for being with me. Take care. Bye.